Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we cover Rutherford versus United States, decided yesterday, May 28, 2026, 6-3. Justice Barrett wrote the majority. Justice Sotomayor dissented, joined by Justices Kagan and Jackson.
And the bottom line, two men serving sentences that Congress itself later decided were too harsh. Sentences running 42 and 70 years, asked the Supreme Court for a shot at release. The court said no.
Not because they didn't rehabilitate, not because their situations weren't sympathetic. The court said the very law Congress passed to reduce those kinds of sentences cannot also serve as a reason to cut their existing sentences short.
The government calls that principle. The dissent calls it cruel logic. We'll get into both.
Before we dive in, quick reminder to please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow us on LinkedIn for written rundowns. Just search the High Court Report. Questions about this case? Reach out on LinkedIn or email us at scotus.cases.pod@gmail.com. All right, here's what you need to know.
Let's start with the people at the center of this case, because the human story matters a lot here.
It really does. Daniel Rutherford, 25 years old in 2003. He committed 2 armed robberies at gunpoint. A jury convicted him of several crimes, including 2 counts of carrying a firearm during a crime of violence under a federal law called Section 924C.
And here's where the math gets staggering. At the time, federal law required something called stacking. Each additional gun count triggered a mandatory 25-year sentence that ran consecutive to the first. So count 1, 7 years mandatory. Count 2, 25 more years on top of that.
Rutherford's 2 gun counts locked in a 32-year minimum for those charges alone. Total sentence, over 42 years.
Then there's Johnny Carter. In 2007, Carter participated in a string of armed bank robberies with co-conspirators. They stole about $250,000. No one fired a gun, no one suffered injury. Carter's co-conspirators took plea deals and received sentences ranging from 10 to 23 years. Carter went to trial. He lost. 3. Section 924C, convictions. Sentence, 70 years. 57 of those years came from the stacked mandatory minimums alone. Carter walked into prison at 29 years old. That 70-year sentence meant he'd die there. And here's where things get complicated. In the 2 decades since those convictions, both men transformed their lives. Rutherford completed over 50 educational courses, received only 2 minor infractions in a decade, and even secured a post-release job to help support his deceased sister's 5 children. Carter's district court judge called him, quote, the kind of model prisoner that our system tries, but too often fails to produce. He earned a GED, completed vocational training, mentored other inmates, and maintained a perfect disciplinary record for 8 straight years.
And then Congress stepped in. In 2018, Congress passed the First Step Act, described by the Supreme Court itself as a landmark piece of legislation that changed the federal sentencing system in numerous ways. One of the biggest changes, Congress eliminated that 25-year stacking requirement for first-time offenders. Under today's law, Rutherford would face a 14-year mandatory minimum, not 32. Carter would face 21 years, not 57.
But, and this is a massive, but Congress made that change prospective only. It applied to offenders not yet sentenced. For Rutherford and Carter, already serving their sentences, the old rules stick.
So how did this get to the Supreme Court?
Both men filed for what's called compassionate release. That's a legal mechanism in federal law, Section 3582C1AI, that lets a judge cut a prison sentence short if the judge finds extraordinary and compelling reasons for doing so. Their argument, the fact that Congress itself recognized the old sentences were too harsh and reduced them for future offenders, creates exactly the kind of extraordinary and compelling circumstance that justifies relief. The Third Circuit said no, twice. Once for Rutherford in 2024, once for Carter shortly after. The court held that the nonretroactive change to the gun crime law cannot serve as an extraordinary and compelling reason. It also struck down a 2023 Sentencing Commission policy statement that had tried to allow courts to consider exactly that kind of sentencing disparity.
The circuit split hard on this. The 1st, 4th, 9th, and 10th circuits had said such disparities can factor in. The 3rd, 5th, 6th, 7th, 8th, and DC circuits said they cannot. That kind of split is exactly what gets the Supreme Court's attention. The court granted certiorari in both cases, consolidated them, and heard oral argument on November 12, 2025.
So what exactly did the court need to decide?
The formal question: when Congress declines to make a sentencing amendment retroactive, as it did with the First Step Act's gun crime changes, can the resulting sentencing gap count as an extraordinary and compelling reason to reduce a sentence under the compassionate release statute?
In plain English, if Congress reduced a sentence for people convicted after a certain date but left older prisoners behind, can a judge say that gap alone, or as part of a bigger picture, makes this case extraordinary enough for compassionate release?
And the statute itself matters here. The compassionate release provision says a judge may reduce a term of imprisonment after considering the sentencing factors, if the judge finds extraordinary and compelling reasons warrant such a reduction. Congress authorized the U.S. Sentencing Commission, the expert body that writes sentencing guidelines, to define what those words mean. The Commission in 2023 added a new category: unusually long sentence. It said courts can consider a change in law if the sentence qualifies as unusually long. The prisoner served at least 10 years. The gap between old and new sentence qualifies as gross, and the court gives full consideration to that individual's circumstances.
The majority invalidated that commission policy statement. The dissent said that move dramatically overstepped.
Let's walk through the majority's reasoning. Justice Barrett started with the statute's text. Extraordinary means most unusual, far from common, having little or no precedent. Compelling means irresistible, forceful enough to demand attention and respect. Put together, extraordinary and compelling reasons must be especially unusual and convincing.
And the majority's first move is nonretroactive sentencing changes are not unusual. They're the norm.
Exactly. Congress almost always applies new sentencing rules only going forward. When Congress changes a penalty, the ordinary practice, the court actually quoted from its own prior decision, Dorsey versus United States, from 2012, the ordinary practice remains withholding that change from defendants already sentenced. That's not extraordinary. That's Tuesday.
And on the word compelling, the majority says, how can Congress's deliberate choice not to extend new penalties to already sentenced prisoners simultaneously count as a compelling reason to undo what Congress decided? That's circular. It treats Congress's own judgment as the reason to override Congress's own judgment.
Barrett also anchored the analysis in what compassionate release has always meant historically: terminal illness, permanent medical conditions, aging, family crises, the Bureau of Prisons, the Sentencing Commission, courts going back to the 1980s. They all focused on the prisoner's personal circumstances. A change in sentencing law sits nowhere near that heartland.
Then the majority addresses two counter-arguments. First, petitioners said Congress only banned one thing from counting as an extraordinary and compelling reason: rehabilitation alone. So everything else stays on the table.
Barrett called that a misread of how negative implication works in law. Ruling out one item doesn't mean the universe of everything else gets approved. She used a memorable analogy. A dietitian tells her patient, pasta alone is not an acceptable dinner. That doesn't license the patient to eat fried chicken and funnel cakes. The dietitian singled out pasta for a specific reason tied to that patient's habits, not to open a general permission slip. Same with Congress singling out rehabilitation. It did that to signal a break from the parole era's obsession with rehabilitation, not to greenlight every other conceivable factor.
Second counter-argument, courts have broad discretion to consider all relevant information when modifying sentences. And the sentencing factors Congress listed include the need to avoid unwarranted sentence disparities. Doesn't that sentencing gap fit right in?
The majority's answer: you're skipping a step. Before a judge weighs those factors, the prisoner must first clear a threshold, demonstrating extraordinary and compelling reasons that actually warrant compassionate release. That's a gatekeeping requirement, not a free-for-all. The majority distinguished a 2022 case, Concepcion versus United States, where eligibility for a reduction was already conceded. The only issue was what a court could consider when calibrating the amount of the reduction. Here, eligibility itself is the dispute.
And Barrett ended with a warning about where the majority read this logic leading. If a non-retroactive sentencing gap can factor in as extraordinary and compelling, What stops a judge from treating her own disagreement with a mandatory minimum as a compelling reason to release someone? At oral argument, the prisoner's lawyers declined to rule that out. Barrett quoted a 200-year-old case, United States versus Wiltberger from 1820. It is the legislature, not the court, which is to define a crime and ordain its punishment. A judge can't use compassionate release to second-guess Congress's judgment on mandatory sentences.
Now the dissent, and Justice Sotomayor comes out swinging. Her central objection starts with framing. The majority, she says, asked the wrong question. The right question isn't whether the statute's text bars consideration of sentencing disparities. It's whether the Sentencing Commission, which Congress expressly delegated authority to define extraordinary and compelling, acted reasonably when it said courts can consider such disparities in narrow circumstances. The court, in her view, substituted its own reading for the Commission's. Congress handed that definitional job to the Commission. The court's role, citing Loper Bright Enterprises versus Raimondo from 2024, the major administrative law case, the court's role stays limited to ensuring the agency acted within reasonable bounds. The Commission did.
Sotomayor also pushed back hard on the majority's nonretroactivity is the norm logic. True, she says, but everyone ages, everyone falls ill, everyone loses family members. Those things are also the norm. Yet, everyone agrees. Those ordinary human experiences can constitute extraordinary and compelling reasons for compassionate release. The key isn't whether any single factor looks ordinary in isolation. The key is whether all the circumstances together rise to an extraordinary level. And she backed that up with real data. In fiscal year 2024, defendants filed 3,015 compassionate release motions nationwide. Courts granted relief under the Commission's unusually long sentence category, the one the majority just struck down, exactly 98 times, out of 130,000 plus people in federal prison. That's not a floodgate opening. That's a very narrow door.
Sotomayor also made a historical argument. Courts have considered all relevant information at sentence modification proceedings for centuries. Conception confirmed that courts' discretion at such proceedings covers everything unless Congress expressly restricts it. Congress knows how to restrict courts' discretion when it wants to. It did exactly that when it banned rehabilitation alone from counting. Its silence on non-retroactive sentencing changes means the default holds. Courts may consider them.
She even invoked Justice Scalia, not usually a dissenter's natural ally. In Setzer versus United States from 2012, Scalia acknowledged that when unexpected state court developments produce an unfair sentence, compassionate release under the statute provides a mechanism for relief. That's the opposite of confining compassionate release to personal circumstances.
And on the majority's slippery slope, the fear that judges will start granting compassionate release to override mandatory minimums. Sotomayor called that unfounded. Judges impose mandatory minimums in tens of thousands of cases every year. In 2024, courts granted compassionate release only 481 times total on any ground. There's no evidence that compassionate release functions as a loophole around mandatory sentences. If outlier abuses happen, the government can appeal, Congress can legislate, the Commission can issue new guidance. The solution, Sotomayor wrote, is not for this court to conjure categorical limitations on courts' discretion that neither Congress nor the Commission imposed.
That's a sharp line. The majority says we're reading the statute. The dissent says you're rewriting it.
All right, time for what this actually means.
For Daniel Rutherford and Johnny Carter, the answer today means they stay in prison under sentences Congress itself recognized as too harsh, with no pathway through compassionate release based on that disparity, even combined with decades of rehabilitation and extraordinary personal transformation.
But the practical reach runs far wider. The court's ruling affects thousands of federal prisoners serving pre-First Step Act sentences under the old stacking rules for gun crimes. Every one of them now faces a closed door on this particular argument. Compassionate release motions based on the sentencing gap Congress created in 2018 cannot proceed.
The Sentencing Commission's 2023 unusually long sentence policy category, the one that took the Commission years to finalize, the court struck it down as exceeding the Commission's authority. District courts that had started applying that provision must now stop.
And the ruling raises a bigger structural question about the Commission itself. The majority said courts retain an independent duty to interpret statutes regardless of Commission guidance. That opens a door. In future cases, litigants will argue that other commission policy statements conflict with the underlying statute and should fall the same way. The questions the court left open matter too. Barrett explicitly declined to define the outer boundaries of extraordinary and compelling. She did not say only personal circumstances qualify. She said non-retroactive sentencing changes don't qualify. What about other post-sentencing legal developments, like a state court changing course in a way that inflates a federal sentence? That question remains live.
And the path Congress now controls. If Rutherford, Carter, and similarly situated prisoners ever receive relief, only Congress can deliver it, either by making First Step Act amendments retroactive or by crafting a new legislative mechanism. Courts cannot fill that gap under today's ruling. Bottom line, time. This case drew a hard line in the compassionate release statute. The court held that a sentencing gap Congress deliberately chose not to close cannot reopen through the back door of compassionate release. 6 justices found that principle clear in the text. 3 found it contrary to the Commission's delegated authority and centuries of sentencing practice.
What makes this case worth following closely? It signals how the current court reads the boundary between judicial compassion and legislative judgment on criminal punishment. That line will generate future litigation about the Commission's authority, about what other facts beyond personal circumstances can clear the extraordinary and compelling bar, and about whether Congress steps in to provide the relief the court declined to grant.
2 men who demonstrated everything the criminal justice system says it values: education, rehabilitation, good conduct, family commitment, still lost. Whether Congress responds to that outcome will tell us a lot about where criminal justice reform in this country actually stands.
Thanks for listening to today's High Court Report. Remember, follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out on LinkedIn or email us at scotus.cases.pod@gmail.com.
And if you're moved enough by Rutherford and Carter's stories to take any action, the most powerful thing you can do right now doesn't involve a lawyer. It involves emailing your member of Congress. Retroactivity doesn't require the Supreme Court. It requires a vote.
We're not political advisors. We're Supreme Court reporters, but we'll take that as a natural CTA. Share this episode with someone who cares about criminal justice or thinks they don't. Talk to you soon.